own jurisdiction, of course, you've heard about our county attorney that lost his license to practice law because he brought criminal charges and a RICO charge against a sitting judge, our criminal presiding judge. And at the press conference, when the members of the press asked him, what's the underlying evidence? He kind of backed away from the mic and said, guys, can you help me out here? Literally. I mean, this is what he said. And it's not that any of our judges had the opportunity to have to deal with him any longer. The bar took what they felt was the appropriate remedy. But his case was also thrown out of federal court. And, I mean, that is probably, I don't know that you can think of a worse situation where a county attorney will direct criminal charges and RICO charges against a sitting judge without having any evidence to substantiate. And as a result of that, many prosecutors felt the wrath, I think, in the end. The woman who was working with him, she lost her license as well. The other woman that was working with him was suspended for how long, John?
6 months.
6 months in a day?
6 months.
Just 6 months. So it did reflect well on the agency and clearly on our state, and it's a tough situation.
Right, as the judge just alluded to, and you've heard us speak and me speak about it, your actions, more so, and Al alluded to it earlier, we hold ourselves to a higher standard. That is a trend nationally. We not only look at what we should do as advisory, as aspirational, we as members of an Attorney General's office should take that as a mandate, not something, well, it would be nice if we could do it, because what we do or what we fail to do could have repercussions not only in your immediate unit or immediate section, but statewide, which is something you definitely don't want to do. And another one, this one from the Midwest. New class of slave owners. Folks, I don't know about New Mexico, but I would think it's like most of the states. Terminology such as slave, slave owner, cretins, knuckle draggers, they tend to be fighting words. They tend to grab the court's attention. And what the court said here is, we're not going to sanction you, counsel. Go figure. Indiana's a very tolerant state. We're not going to sanction you, but such inflammatory analogies, hence slave owner, knuckle draggers, and the like, are inappropriate and have no place in the realm of preserving or protecting or furthering your client's interest. Now I ask you, right result, wrong result. Should this attorney have been slapped on the wrist? I hear a yes. And why is that?
Well, first of all, I think that definitely crossed the line. But second, if nothing happens, I think it encourages that behavior to continue. And so it's important that I think that when lawyers step over the line, that they're held accountable for that. Otherwise, either that lawyer will continue to behave that way, or other lawyers will be involved.
Does anyone think these decisions we've talked about thus far truly hamper or did hamper in these instances the attorney's right to competently and vigorously represent their clients? Folks, the good thing about these presentations, especially when I do, even if you get the wrong answer, I'll repeat it like it's the right answer, so you'll look great to your colleagues. So no matter what you say, it's like T-ball when I give a presentation. Everyone's a winner. And you get out on top. All right. Yeah.
Well, let me give you a backside story to this one. In the years I was sitting on the criminal bench, I had a fellow come in front of me who had been charged with aggravated burglary. He had broke into a person's house and taken some things. He had a gun with him. And the person whose home he broke into also had guns. They have more guns in Arizona. I've never seen so many. Come from New York, nobody has guns, okay? In Arizona, everybody's got 5 guns, it seems. But anyway, the perpetrator was shot in the derriere going out the window. So after sentencing, after the defendant, the prosecutor argued that the gentleman in question was a member of the Aryan Brotherhood, and that I should give him an aggravated sentence because people of his ilk taught their children to hate. And in Arizona, judges are allowed to take into consideration many things in terms of finding what's an aggravating factor. What I said to the prosecutor, I said, what has that got to do with aggravated burglary? You don't have any evidence. Do you know if this fellow has kids? Okay. I said, ideologically, I may have problems with his points of view, clearly, all right? But unless you've got some real evidence, and you're asking me, because you're asking me to sentence a person to about 20% greater time in prison than he'd otherwise get because of the way you might feel or I might feel about the Aryan Brotherhood, but without some evidence here, counsel, is that really a problem? He didn't say anything. And I sense this as a presumptive sentence because that wasn't, I mean, the defense counsel was going apoplectically, so because it wasn't anything that was brought up anywhere. It wasn't even in a pre-sentence report. So those are the kind of things you really have to be careful when you think about civility. When you think about how's the judge really going to handle this? Because I'm sure, I think this prosecutor was talking to me, thought the first time he said Aryan Brotherhood, that was going to ring some bells. But it only rings bells when it's appropriate.
Okay, Michigan, and there's a tie-in to that whole discussion of lethal injections that David introduced, and it's a little bit of a tangential tie-in, but I'm from New Jersey, we're not particularly bright, we go off on tangents, so bear with me. I'm not going to read this, but look at some of the language that this attorney used regarding an appellate panel on a pending matter. He's still before the court. These terms, like the ones I just alluded to, are usually ones that are going to what? Raise more than a few eyebrows. Interestingly, the Disciplinary Review Board refused to sanction this attorney because the comments were made on this attorney's nightly radio show. The Supreme Court of Michigan said, nice try, but as an attorney, you're on the clock 24/7. And whether your comments occur in a courtroom, where they might be subject to contempt, or they occur outside the courtroom, you are charged with those comments. And they did wind up referring the matter back for further discipline. Does anyone know who the attorney might have been?
Jeffrey Feiger.
Jeffrey Feiger. Dr. Kevorkian or Dr. Beth's own attorney. Mr. Feiger is a well-known individual in Michigan, I found out. He has a litany of professional referrals and discipline referrals. This, however, was sort of the worst he had ever gotten. Needless to say, he did lose his matter on appeal, even though the court said they were in no way prejudiced by his comments on his radio show. And so you don't think I'm picking on other states. Even in New Jersey, as shocking as it may be, we have attorneys who engage in an incivil or uncivil manner in court. In this matter, not only did the judge or the attorney use abusive and obscene language towards his adversary, he challenged him to a fight. New Jersey's a big shoving and pushing state. And you know what? That wasn't enough. He goes, not only can I take you, I can take your clients and your witnesses as well. He just kept going. And then, and I'm going to let the judge comment on this because I know judges are very protective of their staffs, he decided to call the judge's law clerk up, and I cleaned up the language in the brackets, but basically he said he was not going to take this copulating manure any further.
If he didn't have his toothbrush, he would have had it with him because he'd find himself in jail until he profusely apologized.
Right. This attorney was suspended for 3 months. He, like Mr. Feiger, has a long litany of such decisions with his name on them. Matter of fact, I think I went against them, and he did challenge me to a fight, but the results of which Al told me I could not tell. Again, in New Jersey, and this one, the reason I add this is look at the third bullet point. This clown, for some reason, thought it would be cute while they were on recess to go in and switch nameplates on counsel tape. I don't know about you folks, but you know what? That's the kind of little thing that is probably going to push the judge over the edge. They're used to attorneys sometimes in exuberance, sometimes in dismay, uttering something they shouldn't. Also attacking on occasion the advocacy skills of their adversaries, but going into court and changing the nameplate was just thought too much by the Disciplinary Review Board, which also suspended him for making these statements and his conduct. Also, and this ties back to something David mentioned, be careful what you say. His comments, which were very obscene and derogatory, were picked up on the courtroom microphone, which had not been turned off by the court officer.
Everything in my courtroom is recorded digitally, audio and visual. I had the occasion in a family court case where the way my courtroom is set up, the witnesses are over here testifying, and the other parties over here. So I'm watching the witness, and it's the wife testifying in a divorce case. And she's in the middle of talking about how the husband's taking all the money and he's giving stuff off to this business, and she stops in the middle and says, "Judge, would you tell my husband to stop calling me up?" Oh. I said, "I didn't hear anything." And she said, "No, he's holding up a pad he's got on it." And I looked over at the husband and his counsel, and the counsel said, "Oh no, Judge, he would never do anything like that." And I said, "You sure?" He said, "Yes." I said, "You sure?" She said, "Yes, I saw it a couple of, because I can't see it, it's back over here." And I said, "Okay, well, let's go to the videotape." And we went to the videotape, and sure enough, there he is. I said to the lawyer, "Ho, ho, 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 that'll cost you $500.
Can we stop just so I can change tape real quick?
Sir.
Thank you.
Court is saying no would have been